Get ready for the dictation in 3, 2, 1, start. The state government shall recognize one or more of its institutions or voluntary organizations in each district as specialized adoption agencies in such manner as may be prescribed for the placement of orphan, abandoned, or surrendered children for adoption in accordance with the guidelines notified under subsection 3, provided that the children's homes and the institutions run by the state government or a voluntary organization for children in need and care and protection who are orphan, abandoned, or surrendered shall ensure that these children are declared free for adoption by the committee, and all such cases shall be referred to the adoption agency in that district for placement of such children in adoption in accordance with the guidelines notified under subsection 3. Stop. No child shall be offered for adoption until two members of the committee declare the child legally free for placement in the case of abandoned children, till the 2 months period for reconsideration by the parent is over in the case of surrendered children, and without his consent in the case of a child who can understand and express his consent. Stop. This court may allow a child to be given in adoption to a person irrespective of material status, or to parents to adopt a child of same sex irrespective of the number of living biological sons and daughters, or to childless couples. Stop para. A bare reading of subsection 6 of section 41 of the Act of 2000 makes it crystal clear that a person is competent to adopt a child irrespective of material status, and also child of same sex irrespective of number of living biological sons or daughters. Stop. Therefore, the embargo for adopting a child of same sex as envisaged under section 11(2) of the Act of 1956 has been done away under the Act of 2000 for adoption of orphaned, abandoned, or surrendered or child in destitution with the solemn object of their rehabilitation and their social reintegration. Stop. Perusal of the impugned order clearly and unequivocally reveals that the learned court below has not addressed the issue involved in the light of provisions contained under the Act of 2000, and has simply non-suited the appellant by relying on the legal embargo under section 11(2) of the Act of 1956. Stop. In my opinion, appellant, who is a responsible officer of the government, has solicited the approval of the court in unison with the per forma respondent to adopt a female child to act as her parent for providing care and protection to her as part of her family. Stop para. In the present era of women empowerment, such an endeavor of the appellant is appreciable and deserves encouragement by the law courts sans technicalities. Stop. Looking to the social status of the appellant and the fact that she is maintaining the child for the last more than 7 months, there remains no doubt about her intentions and credentials. Stop. In the changed social scenario, the Act of 1956 and the Act of 2000 are liable to be construed harmoniously to ensure rehabilitation and social integration of orphaned, abandoned, and surrendered children. Stop. There remains no quarrel that the Act of 1956 deals with the conditions requisite for adoption by Hindus, whereas the Act of 2000 is a special enactment dealing with children in conflict with law and children in need of care and protection. Stop para. As observed herein above, subsection 9 6 of the section 41 of the Act of 2000 empowers the court to allow appellants' parents to adopt a child of same sex irrespective of the number of living biological sons or daughters. The embargo envisaged under clause 2 of section 11 of the Act of 1956 is to yield before the Act of 2000, as it is a special legislation and the Act of 1956 is a general law applicable for Hindus. Stop. Thus, even if there is a conflict between the two legislations, the Act of 2000 is to prevail on the strength of legal maxim generalia specialibus non derogant, which means special provisions will control general provisions. Stop. This legal maxim is ordinarily attracted where there is a conflict between a special and a general statute and an argument of implied repeal is raised. Stop. Honorable Apex Court in the recent judgment in case of Commercial Taxes Officer versus Binani Cement and another 2014 8 SC 319 AIR 2014 SC Supra 1926 has laid down the criteria for determining whether statute is a special or general one. Stop. Relying on some of the earlier decisions, the court held. Stop. Thank you.